On the 13th of January 2023, just a few days ago, the High Court declared that Section 10, Subsection 1 of the Dartmoor Commons Act 1985 conferred that wild camping is not legal in that particular area of Dartmoor National Park. I thought I'd do a little video to talk about exactly what that means and what the implications are, both in a technical legal sense, but in a practical sense as well, because actually they're two different things. Hopefully by the end of the video you'll have a better idea of where you stand in relation to wild camping on Dartmoor and what the implications are for the rest of the UK as well. It's coming up. Welcome back, it's Eddie here from Hiking Britain. If you're new here, please consider subscribing and help my channel grow, but it also means you'll get a notification every time I release a new video. So yeah, just a few days ago, the outdoor community, in particular the wild camping community, were hit with a devastating blow by that High Court decision to make it unlawful to wild camp in a particular section of Dartmoor National Park. And I know it's having ramifications around the outdoor community, in particular Dartmoor National Park Authority and the British Mountaineering Council. There are lots of protests in line to try and combat this particular decision, but also I think Dartmoor National Park Authority are taking advice on possibly challenging that High Court decision. So what's it all about? Well, in 1985 there was the Dartmoor Commons Act, which stated there's open access to all commons on foot and on horseback for the purposes of open air recreation. And Dartmoor National Park argued that it was deliberately worded quite wide to incorporate every type of activity, which included wild camping, although it doesn't specifically say it. Unfortunately, Alexander Darwell and his wife Diana, who have owned about 4,000 acres or 16 square miles of southern Dartmoor, have disagreed with the wording of that. They've taken particular exception to environmental problems and damage that have been happening. The area is famous for wild horses and ponies, but there's all sorts of other livestock, and they say they've been concerned about environmental damage, the fires that have been caused by campers, the rubbish that's been left, the human waste, the dog fouling, all of that, and they took Dartmoor National Park Authority to court, not to change the law, but to clarify the understanding and meaning of the Dartmoor Commons Act of 1985, to clarify whether that meant you were allowed to wild camp as well. So as we know, Alexander Darwell and his wife Diana won that case against Dartmoor National Park. So now it means that if you want to wild camp, technically speaking, if you want to wild camp in that particular area, you need to seek permission from the landowners. So what exactly does that mean? Well, if we talk about it in technical law terms, first of all, before we look at the practical elements of this. So technically now it's against the law to wild camp on their particular land. That means the landowners, if needs be, they have the right, if you wild camp on their land, to approach you and instruct you to leave. And if you didn't, they can take you to court because it's a civil matter of trespass. They can prosecute you under that particular piece of legislation. So that's where that's the understanding of the technical aspect of the law and what it means. And my understanding of a quite complex law system in England and Wales is that there's kind of a gentleman's agreement with the various landowners around the country that you can wild camp on the understanding that you're away from the road, you leave no trace, you're in late, you're out early, and nobody even knows that you're there, so everybody's happy. But what could that mean going forward for the rest of England and Wales? Because this particular High Court decision could set a precedent for everywhere else, where if you want to go wild camping, it might mean under their other areas of the country and their particular bylaws that you might need to gain permission. It's so important for the outdoor community to be able to get in the outdoors and enjoy it, and the vast majority of wild campers, you know, they enjoy it responsibly. They do leave no trace. They're in or out, you don't even know that they're there. It's such an important thing for so many people to be able to do this, and it's understandable why so many people are really upset by this decision and what it could mean, because you don't want to go up onto the hill, pitch your tent up and then some angry landowner coming up and instructing you to leave because it could spoil your night out. So that's the technical law side, but how is this actually going to work in reality, in a practical sense? How's it going to day-to-day affect you as a wild camper if you want to camp in that particular area? First of all, we need to differentiate between civil law and criminal law. This law, which the High Court have been ruling on, is a civil law of trespass. It's not a criminal offence. So because it's not a criminal offence, it has absolutely nothing to do with the police, and the police will not get involved. Even if the landowners threaten that, it's not a police matter, it's a civil matter. Having said that, if criminal offences are taking place on the landowner's land, for example, damage to their property through fires, or there's an assault going on, that then turns into criminal offences, and they can, in theory, contact the police, and the police may investigate, attend the area to deal with the particular incident. Good luck with that. My particular area and my estate where I live in has got horrendous problems with unlicensed scrambler bikes flying all over the place. We can't even get the police to come out for that. Never mind coming up onto the hills and fells to deal with some sort of offence there. So good luck with that. So let's run through a kind of a scenario here. And of course, on the websites of Dartmoor National Park Authority, British Mountaineering Council, they will say that we have to abide by the law. They're gonna say that. But let's say you think, you know, I don't care, I'm going to wild camp on that particular land. And you go up, you pitch your tent up, and then a couple of hours later, Alexander Darwell, his wife, or some other member of the land staff come up and instruct you to leave and threaten prosecution if you don't. Well, the choices for you is you can leave if you want to, or you can say, well, no, I'm here now, I'm going to spend the night. It's going to be very difficult for the landowners to actually do anything about that. They can't physically put their hands on you if they don't suspect that their property has been damaged or is about to be damaged, because you have the right in law to use reasonable force to protect any other person or your property. So if you're just sat in a tent having a brew, you're not committing any criminal offences, which means nobody can come and put their hands on you and physically remove you. If they did, that would be a criminal offence of assault, in which case you could prosecute the other person. So they instruct you to leave. You say, no, I'm here now, I'm going to stay. Now, the only way they could prosecute you for doing that is if they know who you are and your identity, i.e. your name and address. Of course, they're not going to know that, and you're probably not going to disclose that, which means that renders the landowners absolutely powerless to flex that particular law that they've just won in the High Court. But like I said before, if the landowners turn up and you've been had a fire on the grass where you've been cooking food, you've been damaging the land and the environment, or there's a risk that they think property is going to be damaged by your behaviour, or you become physically or confrontational if they suspect criminal offences are going to be taking place, they can technically then start to consider putting their hands on you and physically removing you from their land. Is that going to happen in reality? It's going to be probably not. Well, I'm just trying to explain where we stand with the law. So that's going to be quite an unusual set of circumstances for the landowner to put their hands on you. But I must stress they can only do that if criminal offences have happened, or they think a criminal offence is going to happen on their land. I would suggest that if the landowner does come up, get your phone out, turn on your video bit and just video the exchange between yourself and the landowner, so that you don't leave yourself vulnerable to any sort of malicious or compromising allegations against yourself. You've got a record of the conversation. And you know, if you're a decent person and you've just refused to leave, just enjoy your wild camp, pack up, carry all your gear and just head off. That would be my advice. And there's also been talk about how future mass events could be affected by this particular ruling. For example, and on camera it's escaped my mind exactly what this event is, with thousands of kids who come onto the moors and camp for a particular event. I don't think that's going to be affected in any way, because I think from what I've read on the reports, that the landowners will work with Dartmoor National Park Authority and come to understandings, and I'm sure the landowner will give permission for already established events. I can't see them at all being funny about things like that. They would say all they're concerned about is half-wits and idiots coming onto their land, wild camping and damaging the environment, and that's fair enough. So to me, my interpretation is, in my opinion, that this is all just much to do about nothing. It's all a bit meaningless. All it's done is just clarified an aspect of law to say that this particular bylaw doesn't include wild camping, but I don't think anything is going to change. The idiots and half-wits who leave their rubbish and start fires are still going to do that. Wild campers, the vast majority who are decent human beings who just love being in the outdoors, are going to wild camp. I don't think the landowners are going to be motivated to get out of their warm homes to jump on a quad bike or whatever, head up into the hills and try and evict you from their land. It's going to be really quite unusual for them to do that. So I would just say, crack on, enjoy your wild camping, be sensible, be respectful, and yeah, just enjoy the outdoors. Anyway, that's my thoughts on the matter. I hope you enjoyed this little video. I hope it's clarified a few things and you've got a better understanding of technical law and actually what's going to happen in practice, in reality. Two completely different things. If you like this, give us a little thumbs up. Don't forget to subscribe and get out there and wild camp if you want. Catch you later.